of the day. My name is Ayush Nigam and I am an intern under ubAdvocate under the guidance of Jeevan Prakash Sir. Sir is an advocate on record with Supreme Court of India. Today we are going to discuss a very important topic in the criminal sphere which is related to the bail applications under section 439 of the Code of Criminal Procedure. Now, the concept of bail denotes a form of pre-trial release or removal of restriction and punitive consequences of a pre-trial. Bail is in reality kind of property which is spared, pledged in a court of law, and has an ultimate objective to release a suspect from the detainee, which is the public authority, which is the police, from the police remand actually, on the understanding that the speculated person will return for trial and will not relinquish the bail. He will respect the bail. So bail, if we have to summarize, is a kind of property, is a kind of documentary evidence which is submitted in the court, and on the basis of which an accused person is released, so that the reason why bail is granted is actually because criminal trials and all other trials in India can be very long. So if an accused person is not released in bail and is there in police custody, and after say for 2 to 3 years it is found that the person was not guilty, he might have wasted his 2 to 3 years of precious years of his life. So bail is based upon that concept. Bail per se is not characterized, is not elucidated under the Criminal Procedure Code. As a practice of norm, it is security or a bond which is sworn or given to court in light of legitimate concern. So now we have to come to the most important part of this discussion, which is about the right of accused to get bail even if the charge sheet has been filed. So, my dear friends, liberty of a person is one of the cherished principles of our Indian Constitution. Article 21 deals with it in a very broad hemisphere and prescribes that this liberty, which has been granted to each and every citizen of India, can only be taken away with the provision in accordance with law, with the provisions in accordance with the law. So, does that mean that after the charge sheet has been filed, the liberty of a person has been taken away? Certainly not. After the charge sheet has been filed, we should take into account that the investigation of a person is complete and that person, the accused person, is not needed anymore. Under section 167, the police is out to complete its investigation and report to magistrate. And when it does so, the investigative part is over. There arises no need for a person to be there in police custody, as the chances of him eradicating the material, influencing the evidence, influencing of the witnesses, etc., ceases. In the case of Ram Sarup and another state of Rajasthan, the Honorable Supreme Court has expressed that no court has the power to extend the period of investigation in terms of section 167. And this case is a very big game changer for us, because if the investigation procedure cannot be extended beyond a certain time of limit, then after the first charge sheet has been filed, the chances of getting bail increases. And I have mentioned few of them before, but I'll repeat them in a sequence. First, since investigation is completed, the custody of the accused is no longer required for investigation, because the purpose of him being in custody was to find the evidences, the witnesses, and to collaborate all the material. Since that's done, the person is primarily not required. Secondly, trial when commences, it takes time to complete. We have discussed that 2 to 3 years of the time it can be wasted. So trial when commences, it takes time to complete. Therefore, it may cause injustice to the accused. Remember, the courts of law in India, we follow the rule of law, and over here it is to be taken into account that not only the victim's right have to be secured, the accused rights also have to be secured. There should be a balance. a balance has to be achieved between the rights of the accused and the rights of the victim. It would be unfair for the accused to be kept in custody in jail for that much amount of time for which the trial goes on. Thirdly, which is lastly the most important, evidence would have already been collected by the police, and chances of destruction of concealment of evidence by accused are minimal to zero. However, bail granted would be cancelled. This is a situation. However, bail would be cancelled if prior to this this matter, there had been chances on record, it has been on record that the person has tried to destroy the evidence, influence the witnesses. In that case, the court can deny the bail application. We have another case. This is the case of Abhishek Anand versus State of Bihar. This is a special leave petition 2020 in which Prevention of Corruption Act investigation, it was the Prevention of Corruption matter, and investigation was completed by police and charge sheet was filed. Petitioner in that case filed for a bail application stating that since charge sheet was filed, then the petitioner ought to be released, but the same was rejected by the High Court, and the matter went on further to Supreme Court, where it was challenged by the petitioner, and then the Honorable Court mentioned that since the charge sheet has been filed, and since considering all the facts and circumstances of the present case, it appears that the rights of the accused and as well as the victims are to be preserved, and the petitioner be granted bail and be released. So now we have a definite 2020 judgment, which order from Supreme Court, which states that after the first charge sheet has been filed, the evidence has been collected, everything has been collected by the police investigative authority. Courts have taken into the consideration all the relevant matter. The accused, can be granted the bail application, provided that he does not that there is a certainty that the person accused shall not destroy the evidence, shall not influence the eyewitnesses, and others who concerned. There should be a certainty and there should not be a speculation. If there is a speculation, the benefit of doubt needs to be given to the accused. But if there is a certainty, definitely the bail shall be granted, considering that there are no past criminal records of a person. Friends, bail as a topic is very vast, and it is nearby impossible to cover it in total. But the topic which was covered just before this is equally important. It is actually one of the most important things in you can say in a criminal trial, because bail is something which most people want for. It is actually the most important remedy for a person who has been accused. Now there are situations where a person can be falsely accused, or this can be one of the situation. So bail is needed. So we have already told you about one Supreme Court case, that is the 2020 case, Abhishek Anand one versus State of Gujarat. But now we are going to tell you about one more important case, equally important case, which is of 2012, Sanjay Chandra versus Central Bureau of Investigation, where it was precisely stated that the custody is unnecessary after the charge sheet has been filed, because the petitioner does not seem with certainty to abscond or tamper with the evidence. Over the course of this discussion, we have discussed about the key points, but let's summarize it up and let's wrap this video up with all the key points required for a bail application after the charge sheet has been filed. The first is nature and gravity of the offense. The position and the status of accused with reference to the victim, very important. The likelihood of the accused fleeing from justice. Does the person hold a passport? Then he has to be instructed not to leave the country. It is generally instructed, but I'm telling you one of the situation. And the most important one, this is the cherry on the cake, the likelihood of repeating the offense, jeopardizing his own life, being faced with the grim prospect of possible conviction in the case and of tampering with the evidence. This is very important. A person might be of suicidal tendency. The court has to take note of that. The court will deny application in that matter and see to it that the person does not commit suicide and is safe till the trial concludes. I hope that this video was very informational for you, and on this positive note, I end my video.